Good evening. We're going to get started. My name is Aisha Solomon. I'm the Alachua County Property Appraiser. I would like to thank the City of Alachua, the mayor, and all the city commissioners for allowing us to use their workspace to host this event. I would also like to thank our elected officials. We have Jess Irby, and he's the clerk of the court. We have our tax collector here, John Power. I am honored to have them here, and it's always good when you have elected officials who will do whatever it takes to assist you and facilitate an event like this to make it successful. So I truly, truly appreciate them. Are there any other elected officials out here? Okay, and our law enforcement just walked in, so we feel safer. Thank you for being here. Any veterans? Thank you for your service. I really, truly, truly appreciate you all for being here. Thank you for coming out tonight. I also would like to thank my staff. They're back there at the table. Precious Polycarp and Brian Wanta, who did the grunt work to make sure that this event happens. And for the rest of them that are at the table who's really ready to assist any way possible to make sure this event is successful and all your questions are answered. To give you a little bit of background, to provide you a little bit of background about the Probate and Estate Planning Initiative, one of the Property Appraiser's Office core values is being community focused. This means our office strives to engage with the community both strategically and directly. Our office took a data-driven approach to identify properties in the county that are classified as heirs properties and who has one remaining owner. That means that if your spouse passed away and you're the only remaining owner, you may have received a letter or some type of mailer from us inviting you to this event. What that tells us, there's a need for estate planning. Through this data, we're able to analyze hotspot areas in the community to identify central locations to host events like this one. The data revealed about 1 in 25 residential properties in Alachua County, one out of every 25 in the city of Alachua is at risk of entering a costly and lengthy probate legal process. We plan to continue hosting this event throughout the county to ensure that we are educating as many residents as possible and so that you're knowledgeable about these processes. We will continue to be involved in other probate and estate planning related events hosted by members of the community as well. So we're gonna get started. Thank you all for being here. Danae is from the University of Florida Law Office, and she's gonna be our facilitator here. So thank you all.
Hi, I'm not going to use that microphone because I like to walk around a little bit. My name is Danae Wright. I'm a professor at the College of Law, and I've been working with all of these wonderful elected officials on trying to solve some of the heirs property problems. So we're here to do two things, to tell those of you who are worried that your property might fall into heirs property status and be lost for your family, to tell you some steps you can take to avoid that. And the other thing we want to do is help those of you who are already in heirs property, who might be an heir, who might be living in a home that is not currently titled in your own name yet. That you think it's yours, you inherited it, but it's not yet yours according to the official records that are kept in the Alachua County Property Appraiser's Office. So we're gonna actually start with the second thing first, which is what is heirs property and what do you need to do about it? So I'm sorry that the screens are on the side, so you don't get to look at me. I'd rather you look over there at the screens. Heirs property happens when a landowner dies and the title records are not updated. And by that, we mean, the property appraiser's office has has the name of the owners, and if that person has died, they might know that that person has died, but they don't know who is entitled to the property next. Because in order to do that, you generally have to go to court to get a finding, right? So if you had a will, the homeowner had a will, we need to make sure that that will was valid, right? It wasn't something that was just written on the back of a grocery list. So we need to make sure the will is valid. If the person died without a will, we need to know who the heirs are to figure out who the proper owners are. So there's two main problems with not getting the property updated, the property records, the title updated. Who's doing this? You're doing it. Are you now? Oh, that's interesting. So the first, the slides kind of got messed up. So there's two issues. Donna with Three Rivers is going to talk about one of them. One of them is that the title interest, the home ownership is going to pass to multiple people, right? So if you've got 3 kids, one of those has died, and you've got some more kids, you've got what we call fractionation in the title. So you've got lots and lots of people now who have ownership interests in that piece of land. We've got to deal with that problem. We also have a problem with the fact that if the title is not in the right person's name, you've got what's called cloudy title. And so we're going to talk about those two problems, and Donna's going to talk about fractionation.
Change the order, so we're going to get to cloudy title.
Right, after you.
Yeah.
Okay, so Donna's with Three Rivers Legal Services. They provide assistance both for the probate process and for the estate planning process. So
Okay.
Take it away.
Hi, so I'm Donna McRae. I'm the Deputy Director of Three Rivers Legal Services, and I want to thank you all for being here today. We're really excited to see so many people come out. So this is just to kind of get started. You'll see this is a family tree. So in this situation, we have a grandma and a grandpa, and grandma owns the home in her name only, and she dies without a will. She's survived by her husband and 6 children. Who do you think's entitled to the home? Right. So the husband is only going to get a life estate in the home because he wasn't on the deed, and the children are going to get the remainder interest. So in this scenario, each of the children will get a 1/6 remainder interest. Now the husband's going to get to stay there for the remainder of his life because that's what a life estate is. But if he wanted to mortgage it or sell it, he doesn't have that right to do so unless those children sign over their interest to him. So this is a common misconception that we run into all the time. And we'll talk more about ownership and deeds in a little bit. So then the second scenario is same thing. Grandma owns the home in her name only. She's survived by her husband and 4 of her 6 children. 2 of the children had passed away. So we have, on the left, we have Amy and the spouse had passed away, and Frank and his spouse had passed away. So in this situation, again, the husband gets a life estate in the property, and Brad, Calvin, Donald, and Erica, the 4 children, are each going to get a 6th interest, just like in the last slide. But then the heirs of Amy, which are Amanda, Alex, and Alvin, are going to share a 6th interest. So they're each going to have a 1/3 of a 6th. And then
It's an
same.
18th.
Yeah, an 18th if you do the math. And then on the right-hand side, so Fred, Felicity, again, they're each going to get an 18th. You can imagine how confusing this gets when we're dealing with properties that have not been probated for generations. We have charts that have hundreds of people listed, and they come down to, they could own 1,000th of a share of the property. So these are the types of ownership that exist in Florida currently. So we have tenants by the entireties. This is when a husband and wife own property together or by the entirety. And it's essentially that the marriage owns the property. If one spouse dies, then the other spouse automatically owns it. And normally, procedurally, the living spouse would take a copy of that death certificate down to the county office to show my spouse has died, I need this property, and my name solely at the property appraiser's office. Then we have joint tenants with right of survivorship. That's owned by 2 or more individuals, And what that is, if one of them dies, then the remaining owners get that interest. So we see this a lot with heirs where, or with family members that maybe a parent had a will and did leave it to 5 children, so they each are tenants, and if it's set up that way, tenants by the entireties. Then as they pass, whoever's last living gets it. Some people set up their situations that way. So the thing with joint tenants with right of survivorship, a lot of people think that if, you may have a situation where a husband and wife get divorced and they decide, okay, they're going to have a deed and it's with ownership with right of survivorship. If one of those spouses then gives their interest to someone else, that defeats the right of survivorship, and then they become the third type, which is tenants in common. And that's when it's owned by 2 or more people, and they each have an equal interest in the property. So if you have 2 people that are tenants in common, they each own a undivided 50% interest. If you have 3, it's a third, so on.
All right, so a couple of points about that fractionation idea. So when someone dies, it's going to take a little bit of time to get the property in the names of the kids, right? Probably the kids. And, a year or 2 is fine. But if you wait 30 years to get the title transferred, then we've got this messy fractionation problem because the property can split. You've got 4 living kids, you've got 2 deceased kids with living children. Maybe all of those 6 children have died by the time we get around to doing probate. So avoiding fractionation means doing some proper estate planning so one person gets it, right? That's always good. 2 people get it, but at the very least, going through the process quickly so that it doesn't further fractionate is really is an important part of the heirs property issue. Go back. Oh, sorry. So cloudy title is another problem that exists here, and that happens when, right, we haven't corrected the land records. So grandma's name is still on the deed for the house, and let's say what was one of the kids' names? Bert. It wasn't Bert. Calvin. Okay, Calvin. Okay, so let's say Calvin is actually living in the home, and he's taking care of it, and he's paying the property taxes on it, and he's got the utilities, but the utilities are still in grandma's name, right? Because if he doesn't own it, he might not be able to change the utilities, or he probably just left it in grandma's name. But now he can't get homeowner's insurance for the house because if he doesn't have clear title, he can't get the homeowner's insurance. He can't get a permit if he needs roof work done because he doesn't have it in his own name. So people who own land with cloudy title, so these are the people who, the law says once grandma dies, without a will, her 6 kids inherit it. They are now the owners, but the records are not caught up. The land records have not caught up to it, and so if you've got that cloudy title problem, you can't get homeowner's insurance, you can't get your homestead exemption to reduce your property taxes and protect against creditors. You can't get a mortgage, you may not be able to get FEMA funds. Technically, you shouldn't be leasing the property. You can't sell it. You certainly can't sell it unless you get the title cleared. And you really risk losing the property at tax sale if you don't get the tax bills and pay them. And you might not get the tax bills, right? They might not come to the right address. So those are the 2 problems. One is the property interests themselves have fractionated, and the other is when you've got cloudy title, even the people who own it can't do what they need to do with the home. So then I think we turn to, so what do we do to fix this problem? If you haven't done proper estate planning, or if grandma has not done proper estate planning, we're going to have to go through probate. And probate is like, it's a bad word, but it's really not that bad. And so we have the clerk of the court, Jess Irby here, who's going to tell us all about the probate process. It's mine? Oh, okay, I'm happy to talk about this. So probate is basically the process where you have to go to court. You have to go to court and you have to prove, as the heir, right, as the person who's entitled to the land, to the home, let's say it's Calvin and his 5 brothers and sisters, they need to go to a court and they have to prove that they are the ones that are entitled to ownership of Grandma's house. Now, if they have a will, they take the will, and we're going to have to prove that it's validly executed. So we have to make sure there were two witnesses, and Grandma was not unduly influenced, or she wasn't taking too many meds when she executed her will. So we're going to have to prove the will, that's what we call proving it, to be valid. Or if Grandma didn't have a will, we need to know exactly who her issue are, who her legal heirs are. And those are the people designated by statute as her legal heirs. Okay. You got that one?
Yep.
Okay, good. Donna's going to tell us the next.
Okay. All right, so there's 2 different types of probate procedures. The first is formal administration. Some people refer to this as full administration, but it's technically formal administration. This is can be a long process depending on the circumstances. It normally can take 6 to 8 months. In some cases, it might be a little bit longer. And that is when the person who has passed, we call them the decedent, that they have passed less than 2 years ago. Normally, you're going to do formal administration in that situation. The other, and we'll go into more detail later, summary administration is a much shorter process, and it is accomplished much sooner and a lot less to deal with. You don't have to notify the creditors because in summary administration, in most cases, the person has already passed for 2 years, so all creditors are barred. So if you wait 2 years to file the probate, then you don't have to worry about the creditor issue. So,
Now the clerk of the court is going to impart great wisdom on how the procedures work. Everybody hates going to court, so, we're going to be really nice to Mr. Irby here.
Well, I appreciate that. Well, good evening. It's good to see everybody. I'm Jess Irby, Alachua County's clerk. It's always good to be back here in the fatherland. I tell you, I had to go back to my grandparents' house on the way here just to make sure it was still looking good. There've been a lot of changes to it, but it was still looking pretty sharp. I'll give it that. So the clerk's office, we're talking about the probate is a legal process. And so the clerk's office is your entryway into the courts because there's some filings that have to be done. And so your clerk's office is where you're going to go and you're going to file your petition. So you've got a few different options you can do it. If you have an attorney, they're going to handle it for you, so you don't have to worry about that. But you got different things. You can either bring it in person. They're the courthouse. We're always happy to help you out. If you want to come on down and pay us a visit. You could also mail it to us if you're more comfortable with that. But we also offer the Florida e-filing portal, which is very convenient. You sit at your house. You fill out all your paperwork at home, and then you go to the portal and you submit it to us electronically. We get the documents, and we're able to quickly document. It's really the most efficient and effective method, and you make sure nothing's getting lost in the mail or having to spend your time driving all the way to Gainesville or something like that. Now, there are some filing fees, though, that are involved in this. And so they vary depending on what type of probate process you're going through. And so they could range from $231 all the way up to $400. Now, you got to make sure, though, you can't just file it at any clerk's office in the state. We'd be happy, we'd try to help everybody out, but you can't file everything in Alachua County. So it has to be either where the person that has passed, where they resided. And so if they reside in Alachua County, this is where you're going to file. But if they reside in Marion County, then you're going to have to go on down to Ocala. But say they lived up in Tennessee or they lived in Maryland or somewhere like that, and they just had some property down here in Florida. So they had their winter home was out here in Alachua, and they enjoyed, spending winters down here. And so then you would do a probate process here where their land was if they lived out of state. So these are your different venues. Just make sure you got the venue right. That's one of the quickest ways to get something thrown out by the court if you have the wrong venue. So getting in, we kind of brought up the different types. So your 2 biggest ones, your formal administration and then your summary administration. So some qualifiers to that. Obviously, summary sounds great. It's quick, it's easy. Hey, no problem. Get out of these creditors. But there's certain things you got to have that are going to get you into certain levels of what you're going to do and then the different filing fees. So your formal administration. So this is the one where if the estate has significant value to it. So we're looking at over $75,000, and the person has passed less than 2 years ago. This one you cannot do by yourself. It's just a rule. I can't bend it. Nobody can break it. But you have to have an attorney for this one. And so if there's significant value into the estate, it's less than 2 years, you're going to have to go get an attorney, and they're going to help you out with it, and they're going to be very competent, and it should go very smooth. But there is a $400 filing fee with that one. It's going through the circuit court. So then you're looking at the second one, so your summer administration. All right, so this is the one where it's a little bit, you've got a little bit less value. So now you're looking at under $75,000, or the person has been passed for more than 2 years. And so that's the second thing. So maybe they've been passed for 5, so now you could use this one as well. So the filing fees, they vary though. Also different, if it's less than $1,000, that's the total value of the estate, then you're only looking at $235 filing fee. And then if it's over $1,000, you're looking at $345. We have petitions available for this, because this is the one that you can do by yourself. You don't need an attorney to do this. It's always advised, if you got any questions, always seek out legal counsel. They're going to be able to guide you the best way. But I know that's not an option for everybody. Attorneys are expensive, and sometimes the estate isn't worth that much, and you don't want to go pay somebody $2,000 to go get $3,000. They make a lot of sense. So we offer forms available at the clerk's office to try to help you through this. You can go to our webpage at alachuaclerk.org. We have a form section. We have a whole probate area dedicated to this with all the different forms for probate. We also have a self-help, it's like a DIY type. It's kind of like it's kind of tax season, so this makes me think of it. But it kind of works a little bit like TurboTax or something like that, where it'll ask you questions, and then as you answer the questions, it'll help populate the forms for you. And then with that, you can file it straight through the e-portal, and we'll get it. So another quick and easy, convenient way to do it. There's a third one in here that's not really included because it's not really the focus of tonight, but we do have, there's administration without the formal administration pretty much. But that one's basically if it's just covering the medical bills in the last 60 days of the person's life, the funeral expenses, stuff like that. So we're not really going to get into that one. So hopefully, though, tonight, to avoid the whole heirs situation, everybody's going to have their wills prepared. They're going to be stored safely. We cannot store a will. We're not permitted to do that. I wish we could, but we're just not allowed. But when a person passes, within 10 days, then you do bring it to us. And then we file it away with their proof of death. And then as the legal proceedings begin, then we have it on hand. And so make sure you get that to us within 10 days after their passing. But otherwise, if you ever got any questions about anything, feel free to reach out to me. Hopefully we have the answer, at least be able to point you in the right direction. But they keep me just to the ministerial procedure stuff, so I'm going to leave it to the pros here.
Okay, so there's a lot of steps in the formal administration, as you can imagine. The first step is identifying all of the heirs having an interest in the property. Because this is usually done within 2 years of the person passing, hopefully, it's easy to find those heirs. Because when you get into the summary administration, sometimes it could be that someone has passed 20, 30, 40 years ago. Then it's really hard to find all the heirs. So you have to file a petition with the court. As the clerk explained, you have to notify all of the interested parties. So it's not just that you file it, you have to give notice to everybody that would have an interest in the property. A personal representative does get appointed. That's a person who makes sure that all of the things that need to happen. So for instance, if taxes need to get paid while the probate's going on, or property needs to be sold, or things need to happen, that personal representative is in charge of, doing all those things. They have to file what's called an inventory, which is a listing of all the property that exists in the estate. There's also a 3-month creditors period, so a notice has to be published. It's usually published in the local paper, giving notice to any creditors that might be out there that they need to come forward and state their claim or lose it. So that's a 3-month period. And then a petition to file determination of homestead status gets filed. That's if, if it was the person's homestead that passed away. and you want the court to establish that it was the homestead, and that can't be heard until after that 3-month period ends. And then the property gets distributed to the heirs as the parties agree, or as if there's a will, then what the will how the will says it should be distributed. If homestead is the only asset, then claims can be waived by other heirs. So there's a lot of work that goes into these that, if there are 10 heirs, but one person's been living in the property and everyone agrees, no, we know mom or dad or grandma wanted that person to keep living in that property, then all the other heirs can agree to that and make that happen. So that's what we like to see, is when people get along and, carry out the wishes of the person that passed. And then the final step is to close the estate. But there's a whole lot that goes on in those steps, which is why an attorney is needed in that situation. So then the steps in summary administration is simpler in many ways, but can be more complicated in other ways. So that very first step of identifying all of the heirs can be very difficult, especially if you're talking about 50 or more people, and to find where they are. Did they die? Did they die with a will? Were they married? Did they have children? It's a lot of work to figure that out. So it's really good to keep track of family members and write it down somewhere. Keep a family tree so that you know who the family members are and who the heirs are. And then once all the heirs have been identified, then you file a petition for summary administration and a petition to determine homestead status, and you serve all of the heirs the same as in the formal administration. A lot of attorneys will file one document that is the petition for summary administration and petition to determine homestead. That can be done in all one document. And then the property gets distributed either as agreed upon or as the will says, and then the estate gets closed. So the ultimate goal is to obtain the order determining homestead status of real property, which is entered by the court, signed by the judge, and that determines who gets the property. So there's not going to be a deed because the person who owned the property is deceased. So it's going to be a court order, and that court order is recorded in the public records.
Good evening, everyone. My name is Lali Gomez-Roberts. I'm the Director for the Public Service and Exemptions for the Property Appraiser's Office for Alachua County. And as you all know, you go through 3 rivers, you go through the process, and things get filed with the clerk of courts. But the main question we all ask ourselves is what happens after that? How did this get to the actual custodian of the records for the property for the county, and how does my property get the title changed? And I get to be the owner of this home, which is why I went through this whole process all this time. And the way this happens is after the documents are filed with the official records, the property appraiser will receive copies of the order of summary administration and or the order determining homestead status. Our office generally runs within 2 weeks after the filing of this documentation. Once we receive these documents, we go ahead and we verify the legal description of the parcel, meaning we have to ensure that these orders have been entered for the particular property in which you want the property ownership to be updated. We verify the decedent owner's percentage of ownership in case it's owned by multiple individuals and only one of them has passed away. And that is followed by the update of our records to show the new owners with the correct ownership percentage on record for them. One of the things is that I was actually talking to one of our deed department processors is the fact of we tried as much as we can to pick up these changes. But if for some reason you see that we have not done it, feel free to come to our office. We have an open door policy, we have walk-in policy, and you can bring these documentations or bring to our attention that the case has closed for us to go ahead and make the update of the records for your home. One of the reasons why many of you want the ownership to be updated is because homestead exemption. Homestead exemption is actually a tax break on the property. The tax exemption for homesteaded properties is valued up to $50,000 of the taxable value of the home. And it is particularly given, one of the first requirements is you have to own the property. You have to make it your permanent resident or the permanent resident of somebody who's legally or naturally dependent upon you, in order to receive that exemption, in order to file for it. One of the procedures that our office has taken is, before you even file the documentation with the clerk of courts, if your loved one has passed away, come forward to our office and file for this exemption. The reason that we say this is because a lot of the times we don't know how long probate is gonna take. It could take months, it could take years. And if you fail to submit an application to our office will not be able to make a determination in regards to what year you actually qualify for exemption, because one of the requirements is we have to have an application in our office by March 1st, which is our application deadline. A lot of the questions we ask ourselves is, what happens to that existing tax exemption that was placed on the home? And it's actually a valid question, because in our case, we see a lot of the times that the actual heirs have resided on the home with the actual property owner for a long period of time. And they do wonder, why is it that when this person passes away, the taxes went up? I've been living here. This is my residency too. I have my driver's license, my vehicle registration. I vote from this address. I've lived here my whole life. You know, this is my residential home too. What happens is this homestead exemption is actually an individual exemption, okay? It's a benefit that only overlaps spouses and in some cases minor children. Those are the only reasons why that exemption will stay in place after the original exemptee has passed away. So for those family members that went ahead and managed the property legally or financially, and they went ahead and probate the property, that exemption in particularly will not carry over to you. You will have to file for your own tax benefits on this property. So once the original owner has passed, those exemptions will be removed along with the update of the ownership into heirs. That exemption is supposed to come off, and we are supposed to receive, of course, a new exemption claim on record. One of the main things is what happens while probate is going. What happens to the taxes of the home? What happens to the tax benefits on the property? What happens on that case? Property taxes will be issued without any tax exemption until probate is determined. That means that we have to have the title of the property. That cloud title has to be cleared up for us to make a determination. Why? Because homestead exemption is determined based on the percentage of ownership. We cannot grant you a homestead exemption without knowing exactly how much ownership, how much percentage of the property you actually own. Once that happens, then homestead exemption will be granted accordingly once probate is finalized.
My name is John Power. I'm the tax collector. We're going to get to that later. But I want all of you to take a deep breath and go, whoo. I do this every day and my head is spinning. Yours is too. I know it. Raise your hand right now if you feel like you just took a sip of water from a fire hose. It's so much. But what I want you to do is take a deep breath and understand one thing. These are experts. This is what they do every day. They're here to help you tonight and in the future. You're not going to leave here tonight knowing the answer. You're going to leave here tonight knowing questions that you should ask experts. So go ahead and just relax, take a deep breath. Don't worry about taking notes. Don't worry about trying to memorize all this. Three Rivers is going to help you. Some of you are going to have private attorneys that'll help you. The property appraiser, the clerk of the court, the tax collector, that's our job to help you, and we will. So tonight is just a chance for you to understand how complicated this is and that you do need help, and then you make sure we help you, because that's our job and that's why we're here tonight. So, just relax. We're almost there. So I'm your tax collector, Did anyone in this room, when they were growing up, did they say, I want to grow up and be a tax collector? No, me neither, because we don't like taxes. But I can tell you now, it's a very rewarding job, and the best part of my job is helping people, and the worst part of my job is witnessing people lose their property. So tonight, we're going to educate you on where you can go get resources to where that never happens to you and your family, because it happens. It happens in every family. My family taught me there's 2 guarantees in life. What are they? Death and taxes. What are we talking about tonight? Death and taxes. Woohoo! See, this is really easy. I can't control the death part, but I can control what happens to you. Excuse me, I can't control what happens to you, but we can help control what happens to your property. So my question to you, what you should always think about is, if and when I'm gone, the if is not a question, when is a question, and we all hope it's sometime way, way in the future. When I'm gone, what happens to my property? Well, I'll give you a family example of mine. Had a loving grandmother and loving parents. My father worked 2 jobs to help my grandmother pay for her home while him and my mom paid for theirs. So he worked 2 jobs. Grandma got her house paid off with my dad's help. Eventually, she passed away, and the property was left to my sister. Now, this sister of mine, I love her dearly, but she has substance abuse issues and dependency issues. She was not mentally capable of handling the home and the taxes. She wasn't financially capable, but she was the heir. She inherited the property, and in a year and a half, it was lost. That's a shame, and that should scare every one of you. And what you need to think about is your property that you've worked hard to pay for and secure. Who are you leaving it to? And it's not a gift. It is a responsibility. Make sure you leave it to someone or a group of individuals who understand that owning property is a big responsibility, and make sure they have the mental capacity to own property and the financial capacity to keep it. So let's move into, enough of that scare tactics. I'm not trying to scare you, I'm trying to motivate you, because the answer is here tonight. Let's talk about the timeline for taxes. So this is per state law. This isn't John's law. If you own property anywhere in Florida, this is the state law. On November 1st, property taxes are due and payable. You all know that. April 1st, those same taxes, if unpaid, are delinquent. June 1st, if you don't pay your taxes, state law requires me, the tax collector, to sell a tax certificate. So this is what I want you to think about. Everyone say this term, tax certificate. A tax certificate is where I broker a loan where someone else pays your property taxes for you, and when you get your funds together, you come pay it off. Everyone's happy, everyone goes down the road. Next step, 2 years later, if you don't pay your property taxes, 2 years later, the property can be sold at a tax deed. So the distinction here, there's 2 different things that happen, tax certificate and tax deeds. We'll move along and get into these. What's the difference? One is a loan is sold, that's a tax certificate, your property's not in danger yet. Tax deed, say goodbye to your property, it's gone. And there's only 2 years in between those 2 points. So question and answer. Oh, we're not going to go there yet. Tax deeds. John, why is this so important? Look at these deeds. I don't know if you can read, but in 2018, unfortunately in our county, 122 properties were sold, 62 were sold in 2019, so on, so on. Last year, let's focus on that one, far right column, the blue column. 86 properties were sold because whoever owned them did not pay the taxes. That is a shame. You own something and you lost it because you weren't able to pay the taxes. Of those 86, 17 were heirs. So there were 17 properties out there that were paid for. A family owned it. It was passed to the heirs. The heirs, for whatever reason, didn't pay the taxes. Sometimes they're not financially able to pay them. Sometimes there's 10 or 15 heirs. Who owns the property? All 15. Please raise your hand if you know 15 family members that all agree on something. It's not going to happen. So, John, what if I'm the responsible one out of 15? What if I pay the taxes? Do I own the property? No. Let's hear that again. No. So we've all heard the story. Aunt June's, her niece is living there, and she's shacked up with that crackhead guy. He doesn't work. He lays on the couch all day. They need to pay the taxes. Well, that's family drama. But guess what happens in 2 years? I got to send the file to the clerk, and they have to sell the property. That's a shame. So this is motivation for you to say, you know what, today I'm going to take the legal steps forward and make sure that doesn't happen to my property. And whatever, you know your family, you know who's capable of taking care of it. Now maybe you leave it to Julie and say, you pay the taxes, but let Robert live there. I don't know. You set that up, but don't just leave it to chance. So I need to get rolling here. I like to talk. So question and answer. Number one, can I see if taxes are paid or unpaid on a property? Absolutely. Any property in the whole county, you just look it up. It's public tax information. Just look it up on our website, alachuacollector.com. You can see if taxes are paid. Question number two, how many heirs properties in Alachua County have delinquent taxes? There's 1,671 heirs properties. So 1,671 properties have passed to heirs. Of those, 333 right now today have delinquent taxes on them. That means someone's not paying the taxes, or I should say no one's paying the taxes. How long can these taxes remain unpaid before this property's in danger of being sold? 2 years. That's a short period of time. Very short. I answered this one earlier. If I pay the taxes, do I own the property? No. And I encourage you, if you're part of an heir group, if you're one of 5, if you're one of 50, it doesn't matter. Get in contact with my office, the tax collector's office, ask for the delinquent tax department and say, hey, I'm one of several heirs. What can I do? And they will advise you about the timeline, when you have to do things, and you can work through the process. But just coming and writing me a check, sure, you'll stop the process, but it's not going to change your percentage of ownership. So sometimes that isn't the best thing to do. Sometimes heirs let the property go because they say, you know what? I'm not going to pay the taxes if I don't own the property. There's 10 of us that own it. No one's stepping up. We're just going to let it go. You probably don't want that happening to your property you took care of. So I can't get in your family business, but it's a big decision you have to make. How can I purchase the tax certificate? If you're an heir, maybe you let the taxes go delinquent, but you purchase the tax certificate. It's a little complicated, but our office will advise you on how that works. You can pay the taxes, but rather than paying them, you buy a certificate. That way you're guaranteed you'll get the money back if the property sells. Last one. If I purchase a tax certificate, how can I become the owner of the property? Remember, I said there's two different things. A certificate is more or less a loan that's been put out there for the taxes. The tax deed is an open public auction. Whoever owns the certificate, there is absolutely no guarantee they'll become the owner. They're going to have to go stand in the crowd and get online with all the other people that want to try to buy that property. So buying a certificate against a property does not guarantee that you're going to get the tax deed. So it's still a gamble. So back to the dates, and I'm wrapping it up. November 1st, they're due. April 1st, they're delinquent. A certificate is sold. 2 years, the property can be sold. You don't want that to happen to your property. I'm sure I've scared you to death, but that's why you're here tonight. The experts are here. You're not going to leave here with all the answers you need, but you will leave here with knowing where to go get the answer. And I want you to feel relaxed when you leave, not anxious, but know that you have some work to do because we want to protect you and your property. We don't want families to lose property to people on the internet that are buying them up left and right. Thank you so much. Yes, ma'am.
Wait.
Thank you. Good evening. In referencing to purchasing the tax certificate and the property goes up for sale after 2 years, say I am one of the heirs of the property. Now, if I come and outbid everybody else on that property, being that I am also an heir to that property, will that property now belong to me solely? Will it be mine?
Yes.
So
At
the tax deed sale,
the
the opening bid is all of the back taxes, so all the certificate holders will get paid back. So that's why your question, if I do pay the taxes, should I pay it in a certificate? And I say yes, because at least you'll get your money back, even if you don't secure the property. But if you show up, even if you aren't a certificate holder, or if you are a certificate holder, it doesn't matter. If you purchase the property at a tax deed, even if you were one of the heirs, or a neighbor down the road, or someone that lives in Canada, yes, you are now the sole owner of the property. So sometimes heirs do that. They say, you know what, I'm just gonna gamble and try to get this property in a tax deed. The biggest fear of mine on that, tax deeds are now done online, and Florida is just, every property's beachfront with a gold bars in the backyard, and people from California and all over the world see a tax, and they will buy these properties way above market. So sometimes we get in a bidding war. It's really hard to secure property that way, so it is a gamble. But yes, if you get the tax deed, it wipes out all heirs.
Thank you.
Yes, ma'am.
Before we go to questions, can we come back, let's finish what we're doing, and we'll go to a question and answer. What's our next slide? Who's got the clicker?
Go for it.
I got the clicker. So what happens with the exemption after probate is finalized? I think we went over a little bit with this in regards to, the new owners who contact their office. They will have to revisit the original application, revisit the original application submitted to ensure it's still a good standing claim. So what is a good standing claim? Good standing claim is when you file that application with our office, the only item pending was that ownership, meaning you had your residential factors at the property, driver's license, vehicle, voters. This was your permanent address. State of Florida was your permanent address. You have Florida, you have property, and you have U.S. residency, meaning there's nothing else questionable about your application. Once that happens, we will go ahead and once ownership is updated, we will process your current year, meaning whichever year that was final, and we will submit the previous years to be revised for a correction. Statutorily, we have a 4-year period, meaning we can go ahead and do a correction for current year and 3 years back. That means if you're entitled to that exemption, you had a good standing application, and you received the property, depending on the ownership percentage you receive, that will be how we will grant the exemption, and you could be possibly seen as a refund process to give you back the excess taxes that you paid because the tax bill was issued without a tax break on the property. this is one of those things that happens, unfortunately, and it's what happens if a tax exemption change goes unreported. And this is one of those things that it's a little complicated. So just like John went over the fact, you have 50 members and nobody can get together and figure it out, you could have something like it happens on my family, which is you try to talk to your life mom or grandmother and you try to tell them, hey, we have to get your affairs in order. And the first thing they're going to look at you is you're trying to kill me off already. It does happen. I mean, it happened to me. Sometimes they don't understand the process of, you're not trying to take over their stuff. You're just trying to make sure that when, just like we said, guaranteed, we're all not going to be here one day. When it happens, your affairs are in order. One of those things is making sure that you're standing on tax exemptions on the property. Knowing that, of course, we went over the fact the exemption is owned individually. Will this exemption renew? Will this exemption pass down to me? Will I have to file for an exemption? What is my responsibility on that home? If an heir realizes the property tax exemption or exemptions, we say with an S because we do have other exemptions other than homestead, state claim on the property. That means we have improper exemptions being claimed. They must immediately contact the property appraiser's office. When they go ahead and do that, the claim change must be notified as soon as you realize, okay? That way we ensure that we remove the exemption, either current. What does this mean? Your loved one passed away as of January 1st, meaning if they passed away last year, 2022, the first year that exemption should come off will be 2023, following the year after their death, because as of January 1st, that exemption claim is no longer valid. A lot of you are probably wondering, well, what happens if they passed away longer than a year ago or longer than 2 years ago? Your responsibility is still the same. Contact the property appraiser's office. Now, I could tell you from an internal point of view, when you come forward and you bring us to our attention that an exemption stayed improperly, there are certain concessions that we can go ahead and make. And that is going to be, we're going to cover this where we'll go over a tax lien versus a current year delinquent tax certificate. And this is so we're aware. So what happens is a lot of the times property owners, heirs don't come forward to tell us that a property stayed claimed improperly. Honesty is is the best thing you could do, because why? The truth will come out. When this ownership gets updated and you bring it forward to us, we are going to realize when that original owner passed away. We are going to realize that you've been claiming an exemption incorrectly on this home. That means our office made the discovery. It was not brought to our attention. It was found through our process. That means at some point, and it's not, and one of the things that I like to clarify, this is not something that happens because you do it intentionally. It's something that's the reason we're here. We're trying to educate you what tax exemptions are and how do you get them and how do you claim them and how do they renew. Well, homestead tax exemption, once the original owner files for it, it renews automatically every year. You get a little card at home, says homestead, underneath it says yes, and that happens every single year. You save it for your records, you throw it away, you think, we're sending you propaganda, whatever it is. But that's your receipt. That's your receipt of automatic renewal. And a lot of people don't know that you have to cancel that if that exemption is no longer valid. The process is not a pretty process. I always say that. This is not a pretty process, but we're going to break it down so we could go ahead and understand it. Delinquent taxes, as John mentioned it. Delinquent taxes means that it generates a tax certificate, and the tax collector will have to go ahead and, advertise after 2 years. They'll go ahead and try to put it in as a tax deed sale. Correct me if I'm wrong.
The clerk does it. I would never do anything like that.
Okay, now
Yes.
now we're pointing fingers. But that's usually the process with delinquent taxes. Now, what our office does and what our office procedure is what we call an exemption tax lien. When does an exemption tax lien, when is it created, when is it generated? A tax lien is generated by our office and it's created and it's advised to the property owner that it's going to go ahead and be recorded with the clerk of courts when we identified an improper exemption, okay? So when the property appraiser identifies the exemption, Unlike a tax certificate, that this is a type of lien, that's because you went ahead and didn't pay your taxes. You've been paying the taxes, you've just been paying the wrong amount because you had a tax exemption you weren't supposed to. So this tax lien stays dormant on the home. The reason I want to clarify this is so you're not afraid to bring it forward if this is your case, if you have an exemption that you're claiming improperly. We're not going to go ahead and sell your home. As a matter of fact, the process is we'll identify it. If you bring it forward to us, we'll review the penalties and interest, because there's 3 components to a tax lien: the amount of taxes that you've been saving based off the tax exemption, and then statutorily, there is penalties and interest that go incorporated into this tax lien, that it is under the purview of the property appraiser if she identifies that the exemption was being claimed improperly but not in a malicious way. It's just being renewed because of the fact that the person didn't know. We'll look at all the facts surrounding your case, especially if you brought it forward to us. You were honest enough to tell us, this exemption's not mine. It doesn't belong to me. We'll go ahead and review it. Now, when I said it's dormant, it says it will stay on the property. That means we'll issue the tax lien X amount of years do you received the exemption improperly, and you'll have penalties and interest if that's the case. If not, it might not have it, like I said it before. And what happens is you have 30 days. We'll give you a notification of an intent to record a tax lien on your property, which allows you 30 days to go ahead and either pay the taxes. That means at that point you contact the tax collector's office, and he has a great team in which will try to work with you and try to let you know the process, and they'll educate you very quickly as to what years you need to pay, when you need to pay. They'll work with you on a payment process for that tax lien. Now, if we identify that you don't have to have penalties and interest, you don't accumulate the interest on it, and it will just stay there. If you do have penalties and interest, it will just continue accruing as time passes by. Now, the 30-day notification gives you 2 options. It gives you two notices. It serves to tell you there's a tax lien on the home that's going to be recorded, and 2, it's going to tell you, hey, by the way, if this is your permanent residence, this is the time you have 28 days to go to the property appraiser and file for your homestead exemption. Okay? Just in case if we forgot to do it initially. The liens will stay on the property. Now, if at any point you want to sell the home, the lien will have to be satisfied. You cannot sell it if the lien is still there. That is the only thing. That's the dormant part of it. You can pay little by little. My suggestion to you, you pay all the off the oldest years, but it will stay there until it's satisfied. You could be there 15 years and still pay it, as a matter of fact. Or if you want to sell the home, it will have to be satisfied before we go ahead and make the sale of that home. Notice is, one of the things is notification of the process will only be sent to the mailing address on record. We put this here, or investigations unit or exemptions unit, actually, we will try to find you. We will try to give you multiple notifications. Sometimes we send it to 3 different addresses. What does that go to tell you? It goes to tell you is the following. When your loved one passes away and you are the responsible party, financially, legally, make sure that we have the correct mailing address on record at the property appraiser, because you're going to still receive notification. The property is still there. The original owner has passed away. The property physically is still there. We still need to send you notifications. You're still going to receive an automatic renewal receipt. You're still going to receive your proposed property taxes that go out in August. The tax collector by November 1st still needs to go ahead and send you a tax bill. And we will have to go ahead and notify you of any other changes on the home. So make sure you come to us and tell us that there's a mailing address on the property.
Okay, before we start on that, I'm a professor, right? So we're going to have our quiz. You were all paying attention, right? So now I'm going to quiz you on this. So first, let's just work our way really quickly through what this heirs property problem is. So what are the 2 problems with heirs property? Fractionation and cloudy title. So fractionation happens when all 6 of those kids inherit grandma's house. And Calvin is the only one staying there and he's doing all the work, but the other 5 are living off wherever they're living. They might be in the military, they might be overseas, who knows where they are. Calvin may not even know where they are. Okay, but if Calvin doesn't get this property probated, it's going to continue to split, right? You know those video games where you shoot at something and you hit it and then it breaks into two, and then you shoot at that and it breaks into four? That's what happens. The longer you delay getting this property probated, you're going to have this constant splitting up of the ownership interests. And once that happens, it's really hard to clear the title. So we went through what happens with the clerk of the court. You probably ought to hire a lawyer, especially if it's been a little while, or we do have legal services to help you with the probate process. You'll go through that. You finally figure out, okay, these 17 people are the owners. Now, then you need to go down and we need to make sure that those 17 owners are given information about their taxes, about the property taxes, and that those 17 owners are all told, only one of them is probably living in the home. So only one of them is actually entitled to a homestead exemption, to a reduction in the property taxes. And if that one has been living there for 10 years, paying those lower grandma's taxes at grandma's tax rate, didn't notify anybody, they're going to get slapped on the wrist and they're going to have to pay more. And I can tell you that as these liens rack up, it's very easy. If you've got 17 people that all have a share in a home, and the home's only worth $100,000, we're only looking at $6,000 or $7,000. I can do my math. $6,000 is what any one person's share is. So why would Calvin spend $2,000 every year to pay the taxes if he's only got a $6,000 share in the property? So there's two things here, right? We want a clear title. We want to get it in the names of the living before it spawns into all of these fractionated pieces as soon as possible. We want to make sure that we don't have tax liens, that we are not at risk of losing the property at tax sale. So we go through the probate process, get it done as quickly as possible will help, okay? It will help. But at the same time, you can't avoid everything. We can't avoid death, we can't avoid taxes. But at least if we go and we talk to these people and we find out, what are my options, how many people have shares here, we can maybe at least get the title, all the records retitled in the name of the 17 new owners. But clearly, 17 owners are going to have a hard time managing the property, right? They're not going to agree on anything. Someone's not going to want to pay their share of the taxes. And so if you are a homeowner now, it's really important for you to think, as John said, which of my kids is the responsible kid? I know we all love our children equally. We absolutely love our children equally, but their talent and their financial responsibility is not distributed equally. And so you might want to think, this one child who lived at home, or this child that doesn't have a home, how can I avoid the fractionation problem by making sure that only this one child or maybe two children are the only ones that are going to inherit the property? So how can you do some estate planning to avoid the cost of going to the lawyer for the formal administration, of you having to schlep down to the tax office, and of you having to pay all the taxes for your 16 other co-owners? So if you own land, we're going to now hear about different ways that we can avoid this. So this is the estate planning part, because a few $100s now makes a big difference down the road.
And we're only going to spend a minute on this because I know we're running out of time. So can it be avoided? Maybe. And in most cases, it can be avoided, as we talked about with estate planning, is simply by preparing a last will and testament. It is critical that you have an attorney draft the will. Do not purchase a will at a local office supply store or online, or even online if they say that they're lawyers, because I can't tell you how many times people come to us, the heirs come to us, they have a will in hand, and they say, you know, they left me the home, but something's wrong. It wasn't executed properly, or it wasn't spelled out properly. Just, we see errors all the time with wills. And what happens if a will is determined not to be valid, then it's as if there was no will. So even if there was multiple children and mom said, you're getting the property, if that will's not valid, then all the kids get an equal share. So, you know, we really want to honor your wishes, so it's really important that you have it done by an attorney. There's also some advanced directives, and there's deeds that can be done. One way, very quickly, is that you can do what's called an enhanced life estate deed or a ladybird deed. And what that is that you're determining you're maintaining the property as in your lifetime it's yours, but you're stating who's going to get it immediately upon your passing. The nice thing with an enhanced life estate deed is you can change your mind. As long as it's still within your lifetime and you're still competent to make decisions, you can change your mind and say, I was giving it to Joey, but now Joey is messing up. He's not doing right. I want to now give it to Janie. And so you can make those changes with deeds. And again, you do not want to ever do a deed by yourself. You know, you want to have an attorney do it, a title company. They do lots of deeds and they know all of the procedures and the signatures and all those things. And what we always say is, you don't know what you don't know. So it's just really critical that you get legal advice or go through a title company if you need deeds prepared. And you've heard, you know, mention about Three Rivers. Our services are free. You know, we've been providing services to the community for over 40 years. We have a lot of different grants to cover this work right now. So even if you're not very low income, like most of you know, most of our clients are very low income, we have grants that go up a lot higher these days. So if you need our services, go ahead and give a call, and we'll screen you to see if you're eligible. Okay?
That's to me. All right. So I want to make a couple of comments about the will versus the deed. So, you know, when you go to the bank and you open a bank account and they say, hey, do you want a joint owner? Do you want somebody to be on your bank account with you? You can do that. You can do that with your land. You can Grandma could put Calvin's name on the land with her. And then when she dies, Calvin will own the whole thing. You can do that just like you can do with a bank account. You can also, essentially, what the Ladybird deed does is like a beneficiary designation. So you go to the bank, it's my account, it's still my money, but I can tell the bank if I die, when I die, the property is to go to Calvin. Okay, Grandma could do that. So you can do that with a bank account. The enhanced life estate allows you to do that. Both of those mechanisms, you avoid probate, not that we don't love you, Jess, but you avoid probate, so you don't have to go through that process. You do have to go to the appraiser's office. You do have to show them the deed. You have to show them the death certificate, but you can do that right away. You can do it right away. You can do that 2 days after you've gotten the death certificate. You can get that cloudy title cleared up. You won't run into homestead problems. Your homestead exemption, Grandma's can be dropped, Calvin's can be put on right there very quickly. Everything done in an orderly manner. Hopefully, then you don't become delinquent in your taxes. But you're now the full owner, right? You're now the owner. If you make a will and you leave the property to one person, one child, if Grandma left her home to just Calvin, then we're still going to have to go through probate because we're going to have to make sure Grandma was, of sound mind when she made that will. So we are going to have to go through probate, but we've avoided the fractionation problems, and hopefully we'll get through probate fairly quickly, and we can avoid the cloudy title problem. But we can avoid fractionation by making sure whether you use a will or a ladybird deed or a joint tenancy deed, you can make sure that we don't have it constantly fractionating and splitting, where now you've got too many people, too many cooks, right? Too many cooks in the kitchen. Too many people have too many small shares. That's one of the biggest problems. So, you can come to any of these people, and tonight, obviously, you can ask questions. The Alachua County Clerk also has a self-help center. So we have the do-it-yourself forms that you can do, but you can come to the county courthouse, the civil courthouse, right? So it's the one right next to the Bo Diddley Plaza. You can go in there. There's a library, and our UF Law students are available on Fridays from 11 p.m. to 1 p.m. No, 11 a.m. I'm sorry. God, 11 a.m. to 1 p.m. Every Friday to help you fill out the forms. They can't give you advice, but they can certainly tell you what words mean, help you fill out the forms if you need help. And so we're trying to get more students. We're trying to get another day when people can come and get help. But even if you can't show up between those hours, the Self-Help Center is open, and they are happy to help with filling out the forms if you're doing a summary administration, probate administration. Three Rivers will also, you can contact them, and they can point you to different resources as to how to do the estate planning. Now, a couple $100 now that $400 just for the probate fee. If you spend that $400 now on a ladybird deed, it's all done. It's all done. Or it probably costs you a little bit more to get a will, but it'll cost you more to hire that lawyer to do the probate administration. So do it now, right? Don't put off till tomorrow what you can do today. Anyway, okay, I think that's it. Thank you. I'm going to turn it back over to our property appraiser.
Thank you. Thank you all for coming out tonight. You all had a lot of great questions. I hope that we were able to assist you. As John Powers said, we are all the experts in our offices are available for any other questions that you have after tonight. Our table is back there, so if you have any follow-up questions on your way out, feel free to stop by. I hope that this was a successful summit, and you got a lot out of it. Thank you all.